coming today. The American Red Cross International Humanitarian Law Program works to educate the public on international humanitarian law and other legal frameworks that touch armed conflict. We do this by training volunteer instructors to teach IHL in their communities, but also by providing a stage for webinars. If you are interested in learning more, please contact your regional American Red Cross office to know how you can become involved as a volunteer instructor, and please visit www.rulesofwar.org/webinars to know about the upcoming webinars and view past recordings of events. We will be dropping the link to this to this website in the chat today, so if you want to keep your eyes out for that. Also, we would like to thank our co-sponsor for this event, the American Society of International Law, or ASIL. ASIL is a fantastic organization that tirelessly works to foster the study of international law and to promote the establishment and maintenance of international relations on the basis of law and justice. To learn about how to be a member, membership benefits, or other events hosted by ASIL, please visit www.asil.org. We will also be putting a link in the chat for that. Dr. Chiara Redaelli is a research fellow at the Geneva Academy, an expert on international humanitarian law, jus ad bellum, and international human rights law, and the author of the incredible book, Intervention in Civil Wars, Effectiveness, Legitimacy, and Human Rights. This book is a vitally important investigation, which explains the legal framework surrounding foreign intervention in internal armed conflict, and it illuminates patterns in the developing international legal doctrine, particularly as it has been affected by the human rights model. You can find this book on Amazon and Hart Publishing. At the Geneva Academy, Dr. Redaelli works on the Rule of Law in Armed Conflict, or RULAC, and disruptive military technologies projects. The RULAC project monitors, qualifies, and identifies parties in armed conflicts around the world. The Disruptive Military Technologies Project focuses on law, policy, and protection questions surrounding digitalization and new technologies, non-state actors, implementation and accountability, and sustainable development. We will put links to these Geneva Academy projects in the discussion so you can see their good work. Prior to joining the Geneva Academy, Dr. Redaelli was a research fellow at Harvard Law School, where she worked on a project on peace and aggression and international law. And Dr. Redaelli has also worked for the United Nations High Commissioner for Refugees. She has joined us today to discuss the subject matter of her book, IHL, Human Rights and Intervention. After her presentation, there will be a time for discussion, so please feel free to write any questions you have in the chat. Thank you so much for joining us, Dr. Redaelli. Please take it away.
Thank you so much, Eric, for organizing this event and for having me here. I'm very excited to be here today, so thank you really for this kind invitation. Now, and also thank you for your very kind words and presentation. Now, starting in the middle of things, now try to imagine one president who has to flee his own country due to a civil war or civil unrest within its own country. He flees to another country, and then while he is abroad, he seeks the intervention and the help of the host country where he has found refuge. Now, the host country decides to accept the invitation and to intervene in the home country of the president in order to help him or her regain power. Now, the question is, do you think that this is a lawful intervention in an internal conflict or not? And the problem is, whether you answer yes or no, you have state practice that actually supports your conclusions. So one example that happened recently was the intervention of Saudi Arabia in Yemen upon invitation of the president of Yemen that fled to Saudi Arabia due to the civil war. He asked Saudi Arabia to intervene in Yemen to fight against the rebels, and Saudi Arabia led a coalition, so with other countries, decided to intervene in Yemen to help the president. And then on the other hand, we can think about the intervention of Russia in Ukraine, where Yanukovych fled Ukraine and went to Russia. He asked for Russian intervention in order to regain power in Ukraine, and Russia justified the intervention, mentioning the invitation of President Yanukovych. Now, the problem is that while the intervention of Saudi Arabia in Yemen was not generally condemned by the international community, and it was actually considered from the use of force point of view as a lawful intervention, in the case of Russia, the decision to intervene in favor of Yanukovych was actually criticized by the international community as an unlawful intervention. So you see that state practice is very chaotic, and it gives the impression that it's actually politics more of an international law that regulates interventions in internal conflicts. And now, it is true, and this might be the case, and one of the reasons is actually also the fact that whenever you look at the law, it is very unclear whether under current international law, it is unclear when and under what conditions it is lawful to intervene in a civil war. And this is what I have tried to address with my book, whose aim is, first of all, to clarify the current legal regulation regulating interventions in internal conflicts, and also to see whether there are new trends that are emerging. Now, I talk about trends, and I don't talk about customary law, because well, my main findings suggest that we don't have new customary rules yet. We don't have a clear-cut state practice. The opinion juris is also quite chaotic, but so we can see, and I detected a few trends, but my conclusion is that these trends are not customary law yet. Now, with regard to my main findings, again, first of all, as I mentioned, we are going to see what are my main findings in terms of the new trends that emerge from state practice and opinion juris, but also what emerges is that more in general, when we talk about interventions, both in favor of the governments and the rebels, there has been a shift from effectiveness to legitimacy as criteria to determine whether an intervention in favor of the government or the rebels, which just to clarify, usually an intervention in favor of the rebels is unlawful, but when it happens, we see that the criteria and the justification used to be, or the focus used to be on effectiveness, and it's now more on legitimacy. And we are going to see that human rights, and also to some extent democracy, are emerging as a parameter of this legitimacy. Now, the way in which we are going to do this is by seeing, first of all, what are the traditional approaches that regulate interventions upon invitation, and then we are going to test these approaches against state practice to see whether they stand the test of state practice or not, whether they find a confirmation or not. Now, my book focuses both on the intervention in favor of the government and in favor of the rebels. Now, due to time constraint, I will focus only on the interventions in favor of the government so that we can go more into details with regard to these forms of intervention. And then obviously during the Q&A, we can also address the interventions in favor of the rebels. Now, with regard to interventions in favor of the government, what are the traditional approaches? So, when we look at scholarship and also the justifications provided and the opinion juris provided for by states, we see that probably the oldest theory and approach when it comes to intervention upon invitation of the government is the negative equality or abstentionism approach, which basically says that interventions in civil war upon invitation of the government are always unlawful because they would violate, first of all, the principle of non-intervention in the internal affairs of the states, and second of all, the principle of the right to self-determination. And the reason why they use this legal framework as a reason to say that an intervention in a civil war is unlawful is pretty obvious. whenever you have a foreign country intervening in a civil war, provided that the rebels are fighting in the exercise of the right to self-determination, then if you intervene, you are going to interfere with their exercise of the right to self-determination. And similarly, if you have a civil war, it means that part of the population wants to change its own government, or it's going against the status quo within that country. And this is why an intervention might amount to a violation of the internal affairs of the states. And the only exception, which is admitted by the part of the scholarship that supports the negative equality or abstentionism approach, is counter-intervention, which basically means whenever you have one or more states that are helping the rebels, then it is possible for the state, for the government, to ask a foreign intervention by another country. And the idea here, it's really to counterbalance. So if you have an intervention in favor of the rebels, it means that in terms of right to self-determination and in terms of interference in the internal affairs of the states, well, these rules have been violated already. So in order to reach a negative equality, so basically all parties should fight by the same means, if the rebels obtain an intervention, a foreign intervention in their favor, then the government should have the right to obtain the same. Now, the problem with this exception is that it is unclear whether the counter-intervention should be proportionate to the help that was provided to the rebels. And also the other problem is that usually, because interventions in favor of the rebels are unlawful, they're not going to be conducted in an open way. So it's very difficult to prove whether an intervention in favor of the rebels took place in the first place. And therefore, it's very difficult to see whether there was indeed a right to counter-intervention or not. So apart from this problem with regard to the exception, the general problem with the negative equality or abstentionism approach is that even if it was, for instance, accepted and put forward by the Institut des Droits Internationaux in 1975, issued a resolution supporting the negative equality or abstentionism approach, if we look at the practice of states, we do see that whenever you have a foreign intervention in a civil war, usually whenever it is criticized, it is not criticized because it is unlawful per se. It is usually criticized either because the invitation was issued by an organ or an authority which is not recognized as the de jure government of the state, or because of the modalities in which it took place, which is, for instance, the case of the intervention of Saudi Arabia in Yemen, which was criticized, but more because of the violations of human rights and humanitarian law that took place in Yemen, not really because it is unlawful in general to intervene in civil wars. So this is the main problem with the negative equality or abstentionism approach, and we are going to see it more into details later during tonight. Now, those who are in favor of the negative equality or abstentionism approach, or at least part of them, recently have started to suggest the purpose-based approach, which basically says interventions in civil war are unlawful, just like the negative equality approach. However, there might be exceptions apart from counter-intervention. There are also other exceptions based on the purpose of the intervention. Because if we accept that interventions are unlawful because they violate the right to self-determination and the principle of non-intervention in the internal affairs of the states, then if, for instance, I conduct a military intervention to save my own nationals abroad, then in this case, I'm not really interfering with the civil war. So if I deploy my troops to save my nationals abroad with the authorization of the government, then in this case, this shouldn't be a violation of the negative equality approach and of the of the prohibition to intervene in civil wars. Now, an interesting development, because it's also true that military interventions to save nationals abroad are not very common. But one recent example, which gave the idea of another purpose that might justify an intervention in a civil war, is an intervention to fight against terrorism. So to fight against terrorist groups. And one example that was given is, for instance, the French intervention in Mali in 2011. So when France intervened in Mali, it was upon invitation of the government. But the reason why the government asked for a foreign intervention and the reason why France intervened was specifically to fight only against the terrorist organizations, not only against other groups that were fighting for the right to self-determination, for instance. So France was very careful when they provided the justifications for the intervention in saying, listen, we are really only intervening to fight against terrorists. And this has been suggested by some scholars as a lawful intervention, because if you fight against a terrorist group, you're not really going against the right to self-determination of people, and you're not also interfering in the internal affairs of the state. Now, the problem with this idea is that as long as we don't have a clear definition of terrorism, what happens is that if I am a state, if I am a government and I'm fighting, I'm engaging in a non-international armed conflict against a rebel group, I simply have to define this rebel group as a terrorist organization to be able to ask for a foreign intervention. And if we think, for instance, about the FARC in Colombia, we might claim that the FARC were fighting for political reasons. We might even claim that they were fighting in the exercise of the right to internal self-determination. However, they had been defined for years as a terrorist organization. And so you see that the boundaries between being a terrorist group or a group which is fighting for its right, for the right to self-determination, in that case of the Colombian people, well, the lines are blurring, they're not that clear-cut. So this is why the purpose-based approach presents some issues. And in any case, apart from the intervention of France in Mali in 2011, there aren't many cases that we can mention. Now, if we, on the other hand, accept that interventions in civil wars are lawful under international law, generally speaking, so if we disagree with the abstentionism and the purpose-based approach, then the question becomes a question of agency. So the question is not anymore whether intervening or not is lawful, but the problem is who has the authority to ask for a foreign intervention. And in this case, we have two different theories that have emerged in state practice and also in the scholarship. One theory is the effectiveness approach, which basically says, whenever you have the consent of the organ which is exercising effective control over the territory and the population, then the intervention is going to be lawful. Now, the problem is that obviously during a civil war, it's very hard for the government to prove that it is exercising effective control over the territory and the population, because, well, at least part of the population is rebelling against the government, and also because sometimes the rebel groups do exercise territorial control. So the problem is, what is the threshold? What is the degree of effectiveness that the government must retain in order to be able to issue an invitation from another country? So and the other problem with the effectiveness approach, apart from this threshold and the degree of effectiveness which is needed, is also the fact that if we base our choices on the effectiveness approach and we simply say that the authority which is in effective control is going to be authority capable to ask for a foreign intervention, when we are basically saying that we are endorsing a might makes right approach. And this is why, to react to the effectiveness approach, which was supported mainly in the 1990s, we have a lot of scholars that wrote about the effectiveness approach supporting it about 30 years ago. It started to emerge the democratic legitimacy approach. So this happened following a number of regional organizations like the African Union, but also the Inter-American system that started to issue a number of charters and resolutions, or anyway, legislation, which supported the idea that whenever you have a democratically elected government, if the government is overthrown by a coup d'etat, then the coup d'etat shouldn't be recognized, and the former government should still be recognized as the de jure government of the state. So using this legal basis, part of the scholarship started to say that whenever you have a civil war, the government that can ask for a foreign intervention is the government which has democratic legitimacy, which basically means that it's the government that was elected through free and fair elections. Now, the problem is that if we look at state practice, we see, on the one hand, we see a few cases, well, actually quite a number of cases that support the democratic legitimacy approach. However, we do see also other cases that support the effectiveness approach, because I mean, we just have to look at the governments that are represented at the UN. Not all of them are democratic governments, and yet they are recognized by the international community. So the problem is, how do we use these theories, and whether these theories are actually confirmed in practice or not, and how do they play out? Now, when we test the traditional approaches against state practice, what emerges is that we should distinguish, for the recognition of governments, we should distinguish between the origin of power, so the way in which the government reached power, and the exercise of power, so the way in which the government is exercising its power over the population. And we are going to see now the difference between democratically elected governments, which are not effective, and undemocratic governments that exercise effective control over the territory and the population. And we are going to see what state practice and opinion juris suggest us. So we are going to see what are the new trends that I mentioned at the beginning of the talk. And then we're going to see, in terms of the exercise of power, whether the commission of gross and systematic violations of human rights and humanitarian law by the government has the power to affect the possibility for that government to ask for a foreign intervention. Now, with regard to the origin of power, we have to distinguish. When we talk about democratic governments that have been elected through free and fair elections, then what the new trends that I detected in state practice is that if the government has been in power for some time and was overthrown, or if the government has never been in power, usually, even if there is a non-democratic government which is exercising effective control, the democratic but not effective government is going to be recognized as the de jure government of the state. And one example, there are many others, but one which is probably one of the most famous examples that we can give, and I think it's probably the easiest to understand my point, is the intervention by ECOWAS in the Gambia, and what happened in the Gambia in 2017. So in December 2016, there were the presidential elections in the Gambia. The president, or the person who at the time was the president, lost the elections, while Adama Barrow won the elections. Now, what happened is that the incumbent president refused to recognize the elections result. He claimed that there had been frauds, and he asked the Supreme Court of the Gambia to revise and to control whether indeed there were elections frauds or not. Now, pending this process before the Supreme Court of the Gambia, Adama Barrow, who just won the election, didn't decide that he didn't want to stay in the Gambia, he fled to Senegal. And then while in Senegal, the international community, the majority of the international community, several states, regional organizations like the African Union, but also the UN, recognized Adama Barrow as the de jure government president of the Gambia, to the point that Adama Barrow was sworn in the Gambian embassy in Senegal. So we are talking about a person who just won the election. So he really never had power before. He was, I think, into real estate. So he wasn't really even into politics, simply won the elections. He flees to another country, and yet he is recognized as the de jure government, while the Supreme Court is actually deciding whether the elections were free and fair. And what's interesting is that also ECOWAS conducted a military intervention, even if very brief, because the president was refusing to step down. Now, this is with regard to democratic governments that have been elected through free and fair elections, when you have an undemocratic alternative, which is exercising power in the state. But what when you have undemocratic governments? And then let's think, for instance, about Libya and Syria. So in Libya and Syria, in Libya you had Gaddafi. In Syria, you still have President Assad. They reached power. We didn't reach power through free and fair elections. So they are not necessarily considered as democratic governments. And yet, when they reached power, they were recognized as the presidents of respectively Libya and Syria by the international community. They had representative at the UN. Nobody questioned their legitimacy. However, during the civil war, when the rebels started to be recognized as the legitimate representatives of their own people, these governments, so the government of Assad and the one of Gaddafi, were considered as not being anymore the legitimate representative of the Libyan and Syrian people. Now, this doesn't mean that they were not recognized by the international community as the de jure presidents and the de jure governments anymore. However, it does show that when you have an undemocratic government and you do not have a democratic alternative, then usually the democratic government tends to be recognized. However, when you have an alternative that gives you the impression that it's democratic, for instance, the rebels, they were not elected. So per se, they were not democratic. There haven't been free and fair elections. However, they were asking and they were fighting to have a democratic change and to bring democracy within their own states. And this is why they were perceived as a democratic alternative. And this is when a number of states started to recognize them as the legitimate representative of the Libyan and Syrian people. So now, this is about the new trends that I detected with regard to the origin of power. But what about the way in which power is exercised? And now, in this case, we should distinguish two questions. The first question is, when you have a government that is committing gross and systematic violations of human rights and humanitarian law against its own population during a civil war, and this government wants to ask for a foreign intervention, can it do so? And then the other question is, even if we accept that this government has consent power, can other states intervene to help the government or not? Now, with regard to the first question, we can think, and I think it's very emblematic, the case of Syria. Now, we all know, almost 10 years ago, a non-international armed conflict started in Syria. And then several rebel groups, but also the Islamic State, started to gain power. to exercise territorial control over the Syrian territory. Now, Syria, at some point, it was around 2014, asked the international community, other states, to intervene in favor of the Syrian government in order to fight against the Islamic State. Now, what happened is that a number of states wanted to intervene in Syria in order to fight against the Islamic State. However, they didn't want to intervene and to fight together with the Syrian government because, well, they just recognized it as as not being the legitimate representative of its own people anymore. So they didn't want to be connected to some extent with the Syrian government. And so, as we all know, the US-led coalition intervened against the Islamic State in Syria. However, they didn't use the invitation by Assad as a legal basis to intervene. They actually used the right to self-defense, and they claimed that they were exercising the collective right to self-defense on behalf of Iraq because the Islamic State was using force against Iraq and was using the Syrian territory to launch attacks against Iraq. So on the one hand, we have the Syrian government issuing an invitation, an open invitation, and then countries intervening, doing what Syria actually asked them to do, however, not wanting to cooperate with the Syrian government, but using another legal justification just to avoid the consent of Assad as a legal basis for the intervention. And then we have, in 2015, the intervention of Russia for the same reason to fight, well, at least at the beginning, it was mainly justified as an intervention to fight against the Islamic State. And then in this case, well, Russia simply intervened upon invitation of the Syrian government. And then what happened in this case is that even if Russia and the intervention by Russia was criticized, none of the countries that decided to intervene using the right to self-determination of Iraq as a legal basis claimed that the intervention upon invitation was unlawful per se. So the thing is that this is just one of many examples that suggest that whenever a government is committing gross and systematic violations of human rights, he still has and retains its consent power to ask for a foreign intervention. Now, the problem is, okay, even if, continuing to talk about Syria, even if Assad had the power to ask for a foreign intervention, when Russia intervened to help Assad, was it lawful or not under international law? Are there other rules under international law that prevent a state from providing help to a government that engages in violations of human rights and humanitarian law? And the answer is yes. And there are actually three branches of international law and three main rules that actually go against the lawfulness of foreign interventions in favor of governments in these cases. And the first one is complicity. So in the ILC draft articles on state responsibility, Article 16, it basically says that whenever a state intervenes in favor of another state or provides help to another state with the knowledge of the circumstances of the unlawful acts that the state that is receiving help, so with the knowledge of the circumstances that this state is actually engaging in unlawful acts, and when the acts are unlawful also for the intervening state, then in this case, the intervention could amount to complicity in the commission, in this case, of violations of human rights and humanitarian law. Now, there is a debate whether you need only knowledge of the circumstances or you need also the intent to help the government in the commission of these violations. But this is probably for another day, or maybe we can go more into details during the Q&A. But anyway, so when, for instance, Russia intervened in favor of Syria, we might claim that there might be this basis to say that Russia is indeed responsible for complicity. And then the other rule is the duty to ensure respect for IHL, which is established by Article 1, common to the Geneva Conventions, because obviously, if I am providing help to a state which is committing gross violations of IHL, well, I'm not really ensuring respect for IHL. And then eventually there is one last rule, which comes from weapons law, and in particular, the Arms Trade Treaty. In the Arms Trade Treaty, we have a rule which establishes that a state should not authorize the transfer of weapons or ammunition to countries wherever these countries are engaging in the commission of international crimes, so war crimes, crimes against humanity, or the crime of genocide. Now, to sum up, state practice is still sufficiently chaotic to not to be able to conclude that what we have seen so far amounts to customary law. However, these are new trends, and we saw that the respect of human rights on the one hand, and also democratic legitimacy, so the fact of being elected through free and fair elections, are indeed forms and parameters of legitimacy that are affecting when states intend or consider lawful to intervene or not in a civil war. Now, thank you so much, and I look forward to the discussion.
Dr. Redaelli, that was so informative, so well done. Thank you so much. I know that I learned a lot, and I can tell you that for myself and for someone in our chat, you answered a lot of questions that we had because your presentation was so thorough and so informative. But we do have some other questions. One of which is, what's the threshold for intervention? So is it just is it a military being involved in the conflict, or can certain types of material support also be considered in intervention?
So you mean that the threshold using force?
Right. So could you consider the arms sales, for example, to be considered intervention?
Yeah. So in my book, I focus mainly on, well, almost only, but on armed intervention, meaning from sending weapons to sending troops. However, I do consider also in the book, I do address humanitarian intervention, not humanitarian interventions, but provision of humanitarian assistance. So not military intervention to prevent the commission of war crimes and all the responsibility to protect, but the provision of humanitarian assistance, because in this case, indeed, it is the provision of non-lethal assistance. So you're providing food, water, medicines, whatever is needed by the population. And then in this case, you still have an issue and a question of consent. In this case, it's not really, or not only about how do you identify the government which is in charge or capable to speak on behalf of the state, and therefore also possibly capable of issuing an intervention. But the question is, can a government deny its consent when you have, for instance, the ICRC or other neutral humanitarian organizations that want to provide help to the civilian population? Now, the other question when it comes to this form of intervention, so non-military intervention, is actually also who is the authority that should provide the consent. Because normally, and also if we look at the Geneva Convention, they seem to suggest that it's the government that should provide for the authorization. But if we think, for instance, about Syria, when you have some areas, or Yemen or Libya, or like many other countries, DRC, where you have parts of the territory that are under the control of the rebels, do you really need the consent of the government? Shouldn't you seek the consent of the rebels instead? And I mean, it's pretty obvious why the Geneva Convention seemed to prefer or to talk only or to focus only on the consent of the state. And it's because in 1949, well, the majority of wars of armed conflicts were international armed conflicts. So the issue of rebels controlling the territory wasn't really the issue that we have now, where the vast majority of conflicts are non-international in character. But this is just to say that I do address also these issues. However, the main focus is on military interventions, which are usually the interventions that are there to help the government or the rebels winning the war, not really to, or necessarily to help the population with medicines and food. You're on mute.
Sorry. Thank you so much. We also have, so we have a couple of audience questions, and I'll pepper in some more of my own as we go. Does the right of self-determination support democratic government as preferable to autocratic or dictatorial government?
This is one of my favorite questions because it's very difficult, and I do address, I'm sorry, I go back to my book all the time, but we are also here for that, but I do address the question in the book. It is a very difficult question because on the one hand, international law doesn't require a specific form of government. And this was confirmed also in Nicaragua, where by the ICJ in the Nicaragua case, where the ICJ, the International Court of Justice, said, well, you know, there is no right to intervene in order to change the form of government because you don't like the fact that in Nicaragua there is a communist government. So this suggested that, and not a democratic one, but so this does suggest, and it's a well-established principle in international law, that whenever a population, that the people can decide their own form of government, and it doesn't have to be necessarily a democratic form of government. Now, the other question is, the right to self-determination says that the people have the right to choose their own form of government and political, social, economic system. Now, do we consider, when we have a dictatorship, we presume that if the people are not rebelling, it's because the government reflects the will of the people. The question is this the case or not? And if we don't consider that simply because the people are not starting a rebellion, well, it doesn't mean that they're fine with living in a dictatorship, then does it mean that de facto, unless you have free and fair elections, you're never going to let the people exercising the right to self-determination? Now, this is an open question, and I don't feel like saying that we should then claim that there is a right to democratic entitlement. And even Frank, who was the professor, the scholar who suggested this right about 30 years ago, he recently, a few years ago, he published an article where he said, well, it's still an emerging right. So even the person who put forward the right to democratic entitlement years ago still now doesn't claim that it's actually part of customary law. However, I mean, it is an open question, and it's something I've been thinking about a lot. So thank you for this question.
That was great, thank you. So we have another audience question here. So in your academic opinion, how would you characterize Eritrea's involvement in the Tigray conflict in Ethiopia? Is this lawful, since it seems to be at the invitation of a democratically elected president? At the same time, Tigray forces claim some version of self-determination.
I missed a part of the question. How do I?
Sorry, so I think it's, I think he's asking about involvement, the Eritrean involvement in Tigray as the democratically elected president of Ethiopia invited them, but Tigray forces claimed determination within the region.
Yeah. Yeah, it's it's a very good and interesting question. Now, if we do agree, so the way in which Tigray and the non-international armed conflict in Tigray started, I don't think necessarily that it was, or better, no, let me rephrase. Now, in international law, there is no right to rebel, but rebelling is also not unlawful. So what the armed groups in Tigray did when they started, which were basically the authorities in Tigray, when they started the conflict, under international law, they weren't necessarily doing something lawful or unlawful. Now, the problem is, are they fighting for the right to self-determination? The problem is, under international law, well, we might claim that they are, but under international law, whenever you want to exercise your right to self-determination, the problem is, do you have a right to use force in order to exercise it? Do you have a right to secede, for instance? And usually the answer is, whenever the state gives you some form of leeway, so some form of independence, like for instance, Quebec in Canada, or there are many other examples, you can use your own language and everything, then in this case, you don't really have a right to create your own state. However, there are some scholars that claim that there is a right to remedial secession whenever you want to secede, to exercise your right to self-determination, and you're not allowed to by the government. Now, things escalated quite quickly in Tigray, and it all started with taxes and elections that were happening or not because of COVID. Now the question is then, okay, but so even if we claim, and I don't think it's the case, that they have a right to remedial secession, do they have a right then to ask for a foreign intervention? And based on the trends that I have highlighted, I don't think that they necessarily qualify as a democratic alternative to the government. But it's also true that the intervention is very controversial. Again, we are talking about trends. So probably talking simply about international law as it is, the intervention was maybe lawful. But again, they don't necessarily qualify as a democratic alternative. So they seem to confirm the trends as well.
Thank you. Okay, and I think you've answered a couple of other questions with that, and also with your previous question answer. So one thing that that came to mind is that you had mentioned that in this final slide, we're talking about governments that were committing gross and systematic violations of human rights in IHL, and during a civil war. Is there what about governments that may request assistance or intervention that had committed human rights violations prior to the outbreak of the civil war, but that has since stopped just because they've been so enveloped in the war, they're no longer committing human rights violations, but they were prior to the outbreak of conflict?
Yeah. So if we are talking simply about generically human rights violation, then I guess every government at some point and at some level violates human rights. If we talk about gross and systematic violations, so of human rights, so something a bit more, I wouldn't say more important, because all human rights are important, but a bit bigger in terms of scale and effects on the population. The fact that the government was committing it before, just like the fact that the government is committing it now, doesn't mean that he loses the power to ask for a foreign intervention. If the government was engaging in these violations before, even more so, this is not going to prevent the government from asking for a foreign intervention. And with regard to the lawfulness of the intervention in favor of this government, then complicity or the duty to ensure respect for IHL and also weapons law, they do require, so in order to prevent foreign countries to provide help, it is necessary that the violations are happening now when the intervention happens. While if they were happening before, then if I intervene now to help you, but you committed a crime 10 years ago, then it's not complicity anymore. So no, I don't think that, I mean, obviously it might then affect whether the government is going to be recognized or its legitimacy, or, you know, it's likely that maybe the international community might recognize an alternative because of the violations committed by the government, but per se doesn't deprive the government from its consent power.
Thank you. We have another audience question here. How would we evaluate intervention in situations between openly non-democratic governments like the GCC intervention in Bahrain? How would we evaluate intervention in situations between openly non-democratic governments like the GCC intervention in Bahrain?
So if you have an undemocratic government that intervenes, the fact that the intervening government or state is not democratic is not an issue per se. Because the problem here is not who is intervening. The problem is whether the authority that is issuing the consent or the invitation has the authority to do so. And so the question is, if this government that receives the help, so, or who is asking for the intervention, is this government still recognized as the jure government, even if it's not democratic? And the answer is what I mentioned before. So if you don't have a democratic alternative, then usually this is the government that it is going to be recognized as the de jure government. So if, for instance, Syria issued an invitation to fight against the Islamic State before the outbreak of the war, I mean, obviously we are then in a pre-civil war phase. Well, the Syrian government was still recognized, and I mean, as I mentioned before, it still is recognized as the de jure government. So the fact that it's undemocratic per se is not determinant. What matters is whether you might identify a democratic alternative.
Okay. Now, one question that came to mind as well is when and you touched on this a little bit in former questions and in your presentation, but I just maybe just wanted to get a more of a direct answer on is what if the government and I think this is going to be the last question because unfortunately we're running out of time, but what if the government in question switches from being the government to the rebel to the non-government force? And I'm thinking, you know, you can think of your example in Ukraine where Russians were initially intervening on behalf of the government, and then, you know, the situation completely changed and we're intervening on behalf of a rebel, non-state actor.
So in that case, you have to see whether the invitation was issued when the government was still the government. So for instance, in the case of Russia, Yanukovych was still the president when he was in Russia. And actually, I mean, because the problem with Yanukovych is that there was they did vote in the parliament, in the Ukrainian parliament. The problem is that they didn't have the quorum, so not enough people were in the room in order, according to the Ukrainian constitution, to decide whether Yanukovych was going to remain the president or not. So the majority of votes were against Yanukovych, but not enough people voted according to the Ukrainian constitution. However, the majority of states simply ignored that and said, well, you know, Yanukovych is gone and he's not the government anymore, the president. So we recognize the new president. So, I mean, in this case, if you issue an invitation while you are the president, then the intervention is going to be lawful, even if then you lose power. While if the invitation is issued later, so when you're not the president anymore and when you're not in power, then if you are the opposition group, then generally speaking, it's an unlawful intervention.
Thank you so much. So that's all the time we have for today. If we get further questions, can we pass them along to you via email?
Of course, yeah.
Great, thank you. And also, if anybody has any questions, they can just contact us at the American Red Cross. But please visit the links provided in the chat for the work that the American Red Cross does, the work that ASIL does, and the work that our esteemed guest, Dr. Redaelli, does. I just want to thank everybody again for joining us today, and special thanks to you, Dr. Redaelli, for lending us your time. I know that it's a little bit later where you are, maybe, but thank you so much. This was such an interesting and informative event. I learned a ton. I'm sure everybody watching learned a ton. I'd also like to thank our co-sponsor, the American Society of International Law. I hope everybody enjoys the rest of their day.
Thank you so much.
Bye-bye.
Thank you, everyone. Bye, bye-bye.
Ciao, a bientôt.